The cross that shook the courtroom. The Tampa County Courthouse had seen countless disputes, from high-stakes corporate battles to bitter divorces, but nothing prepared it for the storm about to unfold on a warm Tuesday morning. Savannah Blake, one of Florida's most respected litigation attorneys, stepped through the massive wooden doors with her briefcase in one hand and the other adjusting the lapel of her navy blue blazer. To her, this hearing was routine, just another contract dispute she could argue blindfolded. But as she made her way to the defense table, Savannah immediately felt something was off. She caught the stare of Judge Howard McAllister, a stern figure known for running his courtroom with iron precision. But he wasn't focused on her argument notes or her legal credentials. He was staring at the simple gold cross hanging just below her collarbone. The courtroom, sparsely filled that morning, fell into a strange hush. Then came McAllister's gravel-edged voice. "MS. Blake, I must remind you, religious symbols are not permitted in my courtroom. You'll need to remove the cross or face a fine." Savannah blinked, barely registering the threat. "Your Honor," she replied calmly, "that cross is no different than a wedding band or a pendant with a family photo. It's personal. It's private." McAllister's face stayed cold. "That's not how I see it. Remove it, or I will fine you for disrupting courtroom neutrality." This was unprecedented. Savannah wasn't being fined for misconduct or grandstanding. She was being punished for a necklace. But what disturbed her wasn't the fine, it was the principle. She folded her hands on her briefcase, her posture composed, but her heart had already drawn a line. "Before we proceed," Savannah said, "I'd like to object formally and state my position on record." McAllister smirked, glancing at the clock. "MS. Blake, this is a business hearing, not a civil rights seminar." "I understand that," she responded, her voice unwavering. "But the First Amendment doesn't recess because you find personal expression inconvenient." That made him pause. His back stiffened. The court reporter's fingers froze above her keyboard. Everyone sensed this wasn't just about jewelry anymore. Savannah continued, "You're attempting to penalize me for wearing a symbol of faith. Let's unpack the legality of that." McAllister rubbed his temples, visibly annoyed, but Savannah reached into her briefcase with steady hands. She pulled out a single sheet and laid it gently on the table. "I don't have time for this theater, S. Blake," the judge said flatly. Savannah looked up. "Neither do I, Your Honor, which is why I'm here to address the matter with the law." McAllister leaned forward, lacing his fingers, preparing for a confrontation he didn't anticipate. "You claim this cross violates neutrality. So tell me, what precedent supports that?" The courtroom held its breath. He said nothing. Savannah tapped the paper. "Under the First Amendment, individual religious expression is protected, especially when it causes no disruption. Your demand lacks constitutional standing." The judge scoffed. "You're a trial attorney, not a constitutional scholar." Savannah gave him a razor-sharp smile. "Then let's talk case law." She lifted the paper. "Thinker of Des Moines, 1969. The Supreme Court held that individuals do not lose their rights at the door of a public institution." McAllister flinched. Everyone in the legal world knew that case. West Virginia Board of Education v. Barnett, 1943. The court ruled that compelling individuals to hide personal beliefs is unconstitutional. She placed the paper down again. "Would you like me to continue, or are you ready to reconsider the fine?" McAllister tapped his fingers against his chair. He was cornered, and he knew it. "This isn't a religious debate," he tried weakly. "Then why did you make it one?" Savannah countered. There were quiet gasps around the room. McAllister's face hardened. "Enough. With all due respect," she said, "I'll stop when I receive a legal justification. So far, I've heard none." A long silence. Then, "Mark the fine as pending review," the judge said to the clerk. Savannah smirked. "I'll consider that a temporary victory." But she wasn't finished. McAllister had created a spectacle. Now, Savannah was going to make sure it had consequences. "If this fine is upheld, Your Honor, I'll file an appeal immediately. And when that case goes public, I promise the headlines won't be kind. A judge penalizing a woman for wearing a cross? I suspect higher courts will want to weigh in. McAllister inhaled sharply. His pride collided with his dwindling authority. Finally, he muttered, "The fine is rescinded." Savannah smiled. Much appreciated. She had won, but now she had to ensure it mattered. Outside the courtroom, a reporter covering a separate case overheard the incident. Within the hour, the story was online. Florida judge tries to fine attorney over cross necklace. It doesn't end well. Savannah's phone buzzed with calls, texts, and interview requests. But she wasn't chasing headlines. She was planning her next move. Because McAllister wasn't finished. The very next morning, her assistant Morgan stood at her office door, tablet in hand. "You need to see this," Morgan said. Savannah read the Bar Association statement. Vaguely worded, but unmistakably aimed at her. While judges maintain decorum, attorneys must respect courtroom rules. A warning. Then came a formal complaint. Attorney Savannah Blake disrupted proceedings, challenged judicial authority, and acted unbecoming of her role. Savannah let out a humorless laugh. Unbecoming? That's rich. Morgan's face was tense. It's retaliation. Straight up. Savannah nodded slowly. Prescott's trying to flip the story, to paint me as reckless. She'd seen this tactic before. Turn the defender into the accused, bury the issue beneath procedure and politics. "What's the process?" she asked. 10 days to respond. If it goes forward, a review panel, mostly senior judges and attorneys, will evaluate. Savannah leaned back. If McAllister thought she'd go quietly, he was in for a surprise. She picked up her phone and dialed Lisa Monroe, a journalist from Legal Frontline, someone who had covered her biggest wins. "Lisa," she said, "a judge tried to fine me over a cross. I challenged him. He backed down. Now he's filed a complaint to make me look like the problem." Lisa didn't miss a beat. "We're running this. I want it public before he buries it behind closed doors." Lisa agreed. "You'll be on air tomorrow." Savannah hung up, then turned to Morgan. "Draft a statement. Frame this for what it is, judicial overreach targeting personal rights. If he thinks he can intimidate me, imagine what he's done to people without a voice." By the next morning, headlines spread like wildfire. Florida judge under fire after targeting attorney's necklace. Legal experts took sides. Some praised Savannah's stand for First Amendment rights. Others questioned the judge's judgment. Conservative, liberal, independent. Everyone had an opinion. Then came the statement Savannah had waited for. The Florida Judicial Review Board announced it would investigate McAllister's conduct for potential ethical violations. Morgan burst into Savannah's office. "You need to see this." It was McAllister reading a stiff, hollow statement outside the courthouse. "I have always upheld courtroom integrity. I will cooperate fully with the review process." Savannah nearly laughed. "He's still clinging to neutrality. He's trying to save face," Morgan said. "He's failing," Savannah replied. This wasn't just about one case. It was about every person who'd ever wondered whether a judge could silence them with the stroke of a pen. Savannah had drawn a line in the sand and held it. She sipped her coffee, looked out the window, and whispered to herself, "We won." But more importantly, they all did.